Philippine Cases 2017. Points of Law. PRISCILLA ZAFRA ORBE September 6, 2017. When Republic Act No. 6552 or the MANUEL law speaks of paying at least 2 years of installments in order for the benefits under its Section 3 to become available, it refers to the buyer's payment of 2 years' worth of the stipulated fractional periodic payments due to the seller. When the buyer's payments fall short of the equivalent of 2 years' worth of installments, the benefits that the buyer may avail of are limited to those under Section 4. Should the buyer still fail to make payments within Section 4's grace period, the seller may cancel the contract. Any such cancellation is ineffectual, however, unless it is made through a valid notarial act. Representative Act No. 6552, Sec. 3 provides. Section 3. In all transactions or contracts involving the sale or financing of real estate on installment payments, including residential condominium apartments but excluding industrial lots, commercial buildings and sales to tenants under Republic Act No. 3844, as amended by Republic Act No. 63/HW1-89. Where the buyer has paid at least 2 years of installments, the buyer is entitled to the following rights in case he defaults in the payment of succeeding installments. A. To pay, without additional interest, the unpaid installments due within the total grace period earned by him, which is hereby fixed at the rate of 1 month grace period for every 1 year of installment payments made, provided that this right shall be exercised by the buyer only once in every 5 years of the life of the contract and its extensions, if any. B. If the contract is cancelled, the seller shall refund to the buyer the cash surrender value of the payments on the property equivalent to 50% of the total payments made and, after 5 years of installments, an additional 5% every year but not to exceed 90% of the total payments made, provided that the actual cancellation of the contract shall take place after 30 days from receipt by the buyer of the notice of cancellation or the demand for rescission of the contract by a notarial act, and upon full payment of the cash surrender value to the buyer. Down payments, deposits or options on the contract shall be included in the computation of the total number of installment payments made. Respondent's obligation to refund petitioner ensued at the moment it became impossible for petitioner to avail of her rights under Section 4 of the MANUEL law, that is, when respondent sold the property to Rule Y Mana. Interest on it accrued from the moment of the filing of petitioner's complaint, the date of judicial demand. Eastern Shipping Lines v. Court of Appeals, which articulated the guidelines for the reckoning of legal interest that were in EFTBCT when the material incidents of this case arose, explained that in the absence of stipulation, that interest due on a breach of obligation consisting in the payment of a sum of money shall be 12% per annum to be computed from default, i.e., from judicial or extrajudicial demand. Representative Act No. 6552, Sec. 4 provides. Section 4. In case where less than 2 years of installments were paid, the seller shall give the buyer a grace period of not less than 60 days from the date the installment became due. If the buyer fails to pay the installments due at the expiration of the grace period, the seller may cancel the contract after 30 days from receipt by the buyer of the notice of cancellation or the demand for rescission of the contract by a notarial act. ARTURO CCALUB 80 August 30, 2017. When a corporation intentionally or negligently clothes its agent with apparent authority to act in its behalf, it is stopped from denying its agent's apparent authority as to innocent third parties who dealt with this agent in good faith. The doctrine of apparent authority provides that even if no actual authority has been conferred on an agent, his or her acts, as long as they are within his or her apparent scope of authority, bind the principal. However, the principal's liability is limited to third persons who are reasonably led to believe that the agent was authorized to act for the principal due to the principal's conduct. Apparent authority is determined by the acts of the principal and not by the acts of the agent. Thus, it is incumbent upon CALUBAD to prove how RICARCEN's acts led him to believe that Maryland was duly authorized to represent it. Moral damages are not automatically awarded when there is a breach of contract. It must also be proven that the party who breached the contract acted fraudulently or in bad faith, in wanton disregard of the contracted obligation. In addition, the following conditions must be met before moral damages may be awarded. 1. First, there must be an injury, whether physical, mental or psychological, clearly sustained by the claimant. 2. Second, there must be culpable act or omission factually established. 3. Third, the wrongful act or omission of the defendant is the proximate cause of the injury sustained by the claimant. And 4. Fourth, the award of damages is predicated on any of the cases stated in Article 2219 of the Civil Code. Petitioner failed to allege that RICARCEN acted fraudulently or wantonly when it breached the loan MD mortgage contract. Neither is this court convinced that fraud, bad faith, or wanton disregard of its obligation can be imputed to RICARCEN due to its bad business judgment and negligence in putting too much trust in Marilyn. It was not sufficiently shown that RICARCEN was spurred by a dishonest purpose or was motivated by ill will or fraud when it assailed the contract entered into by Marilyn and CALUBAD. In the same manner, exemplary damages cannot be awarded in the absence of evidence that RICARCEN acted fraudulently or wantonly. Finally, in the absence of exemplary damages, attorney's fees and costs of suit also cannot be recovered. Civil Code Art. 1232 provides. Article 2232. In contracts and quasi-contracts, the court may award exemplary damages if the defendant acted in a wanton, fraudulent, reckless, oppressive, or malevolent manner. Civil Code Art. 2208 provides. Article 2208. In the absence of stipulation, attorney's fees and expenses of litigation, other than judicial costs, cannot be recovered, except 1. When exemplary damages are awarded. 2. When the defendant's act or omission has compelled the plaintiff to litigate with third persons or to incur expenses to protect his interest. 3. In criminal cases of malicious prosecution against the plaintiff. 4. In case of a clearly unfounded civil action or proceeding against the plaintiff. 5. Where the defendant acted in gross and evident bad faith in refusing to satisfy the plaintiff's plainly valid, just and demandable claim. 6. In actions for legal support. 7. In actions for the recovery of wages of household helpers, laborers and skilled workers. 8. In actions for indemnity under workmen's compensation and employers' liability laws. 9. In a separate civil action to recover civil liability arising from a crime. 10. When at least double judicial costs are awarded. 11. In any other case where the court deems it just and equitable that attorney's fees and expenses of litigation should be recovered. Rules of Court. Rule 45, Sec. 1 provides. Section 1. Filing a petition with Supreme Court. A party desiring to appeal by certiorari from a judgment or final order or resolution of the Court of Appeals, the Sandiganbayan, the Regional Trial Court or other courts whenever authorized by law, may file with the Supreme Court a verified petition for review on certiorari. The petition shall raise only questions of law which must be distinctly set forth. Metro Bottled Water Corporation, March 6, 2019. Generally, judicial review of arbitral awards is permitted only on very narrow grounds. Republic Act No. 876, or the arbitration law, does not allow an arbitral award to be revisited without a showing of specified conditions, which must be proven affirmatively by the party seeking its review. The Special Rules of Court on Alternative Dispute Resolution, implementing the Alternative Dispute Resolution Act of 2004, mandate that arbitral awards will not be vacated merely on the ground that the arbitral tribunal committed errors of fact, or of law, or of fact and law. As the court cannot substitute its judgment for that of the arbitral tribunal, parties are even precluded from filing an appeal or a petition for certiorari questioning the merits of an arbitral award. On the other hand, arbitral awards by the Construction Industry Arbitration Commission may only be appealed on pure questions of law, though not all will justify an appeal. Consistent with the strict standards for judicial review of arbitral awards, only those appeals which involve egregious errors of law may be entertained. Representative Act No. 876, 1953, Sec. 24 provides. Section 24. Grounds for vacating award. In any one of the following cases, the court must make an order vacating the award upon the petition of any party to the controversy when such party proves affirmatively that in the arbitration proceedings A. The award was procured by corruption, fraud, or other undue means, or B. That there was evident partiality or corruption in the arbitrators or any of them, or C. That the arbitrators were guilty of misconduct in refusing to postpone the hearing upon sufficient cause shown, or in refusing to hear evidence pertinent and material to the controversy. That one or more of the arbitrators was disqualified to act as such under Section 9 hereof, and willfully refrained from disclosing such disqualifications or of any other misbehavior by which the rights of any party have been materially prejudiced, or D. That the arbitrators exceeded their powers, or so imperfectly executed them, that a mutual, final and definite award upon the subject matter submitted to them was not made. Representative Act No. 9285 2004 ch.7 sec. 41 provides. Section 41. Vacation Award. A party to a domestic arbitration may question the arbitral award with the appropriate regional trial court in accordance with rules of procedure to be promulgated by the Supreme Court only on those grounds enumerated in Section 25 of Republic Act No. 876. Any other ground raised against a domestic arbitral award shall be disregarded by the regional trial court. In the construction industry, the 10% retention money is portion of the contract price automatically deducted from the contractor's billings as security for the execution of corrective work if any becomes necessary. This amount is to be released 1 year after the completion of the project, minus the cost of corrective work. H.L. Carlos Construction v. Marina Properties Corporation, 466 Phil. 182, 199-200 2004. Civil Code, Article 1724. The contractor who undertakes to build a structure or any other work for a stipulated price, in conformity with plans and specifications agreed upon with the landowner, can neither withdraw from the contract nor demand an increase in the price on account of the higher cost of labor or materials, save when there has been a change in the plans and specifications, provided, 1. Such change has been authorized by the proprietor in writing, and 2. The additional price to be paid to the contractor has been determined in writing by both parties. Exec. Order No. 1008/1985, Sec. 4 provides. Section 4. Jurisdiction. The CIAC shall have original and exclusive jurisdiction over disputes arising from or connected with contracts entered into by parties involved in construction in the Philippines, whether the dispute arises before or after the completion of the contract, or after the abandonment or breach thereof. These disputes may involve government or private contracts. For the board to acquire jurisdiction, the parties to a dispute must agree to submit the same to voluntary arbitration. Labor Code, Article 219, 212 definitions. An voluntary arbitrator means any person accredited by the board as such, or any person named or designated in the collective bargaining agreement by the parties to act as their voluntary arbitrator, or one chosen with or without the assistance of the National Conciliation and Mediation Board, pursuant to a selection procedure agreed upon in the collective bargaining agreement, or any official that may be authorized by the Secretary of Labor and Employment to act as voluntary arbitrator upon the written request and agreement of the parties to a labor dispute. Manuel Escobar Gr. No. 214300. Bail is the security given for the temporary release of a person who has been arrested and detained but whose guilt has not yet been proven in court beyond reasonable doubt. The right to bail is cognate to the fundamental right to be presumed innocent. The right to bail emanates from the accused's constitutional right to be presumed innocent. It is accorded to a person in the custody of the law who may, by reason of the presumption of innocence he or she enjoys, be allowed provisional liberty upon filing of a security to guarantee his or her appearance before any court as required under specified conditions. Bail may be a matter of right or judicial discretion. The accused has the right to bail if the offense charged is not punishable by death, reclusion perpetua, or life imprisonment before conviction by the regional trial court. However, if the accused is charged with an offense the penalty of which is death, reclusion perpetua, or life imprisonment, regardless of the stage of the criminal prosecution and when evidence of one's guilt is not strong, then the accused's prayer for bail is subject to the discretion of the trial court. In this case, the imposable penalty for kidnapping for ransom is death reduced to reclusion perpetua. Escobar's bail is thus a matter of judicial discretion, provided that the evidence of his guilt is not strong. Rule 114 of the Revised Rules on Criminal Procedure states, Section 4, Bail, a matter of right, exception. All persons in custody shall be admitted to bail as a matter of right, with sufficient sureties, or released on recognizances prescribed by law or this rule, before or after conviction by the Metropolitan Trial Court, Municipal Trial Court in cities, or Municipal Circuit Trial Court, and b. before conviction by the Regional Trial Court of an offense not punishable by death, reclusion perpetua, or life imprisonment. Section 7. Capital offense or an offense punishable by reclusion perpetua or life imprisonment, not bailable. No person charged with a capital offense, or an offense punishable by reclusion perpetua or life imprisonment, shall be admitted to bail when evidence of guilt is strong, regardless of the stage of the criminal prosecution. RPC Art. 267. Kidnapping and serious illegal detention. Any private individual who shall kidnap or detain another, or in any other manner deprive him of his liberty, shall suffer the penalty of reclusion perpetua to death. 1. If the kidnapping or detention shall have lasted more than 5 days. 2. If it shall have been committed simulating public authority. 3. If any serious physical injuries shall have been inflicted upon the person kidnapped or detained, or if threats to kill him shall have been made. 4. If the person kidnapped or detained shall be a minor, female or a public officer. The penalty shall be death where the kidnapping or detention was committed for the purpose of extorting ransom from the victim or any other person, even if none of the circumstances above mentioned were present in the commission of the offense. As amended by Republic Act Nos. 18 and 1084. Rules of Court. Rule 117, Sec. 7 provides, Section 7, former conviction or acquittal. Double jeopardy. When an accused has been convicted or acquitted, or the case against him dismissed or otherwise terminated without his express consent by a court of competent jurisdiction, upon a valid complaint or information or other formal charge sufficient in form and substance to sustain a conviction, and after the accused had pleaded to the charge, the conviction or acquittal of the accused or the dismissal of the case shall be a bar to another prosecution for the offense charged, or for any attempt to commit the same or frustration thereof, or for any offense which necessarily includes or is necessarily included in the offense charged in the former complaint or information. However, the conviction of the accused shall not be a bar to another prosecution for an offense which necessarily includes the offense charged in the former complaint or information under any of the following instances: the graver offense developed due to supervening facts arising from the same act or omission constituting the former charge. B. The facts constituting the graver charge became known or were discovered only after a plea was entered in the former complaint or information, or C. The plea of guilty to the lesser offense was made without the consent of the prosecutor and of the offended party except as provided in Section IF of Rule 116. In any of the foregoing cases where the accused satisfies or serves in whole or in part the judgment, he shall be credited with the same in the event of conviction for the graver offense. Effect of judgments or final orders. The effect of a judgment or final order rendered by a court of the Philippines, having jurisdiction to pronounce the judgment or final order, may be as follows. B. The judgment or final order is with respect to the matter directly adjudged or as to any other matter that could have been raised in relation thereto, conclusive between the parties and their successors in interest by title subsequent to the commencement of the action or special proceeding, litigating for the same thing and under the same title and in the same capacity, and C. In any other litigation between the same parties or their successors in interest, that only is deemed to have been adjudged in a former judgment or final order which appears upon its face to have been so adjudged, or which was actually and necessarily included therein or necessary thereto. petitioner's arguments that res judicata applies since the Office of the Ombudsman twice found no sufficient basis to indict him in similar cases earlier filed against him, and that the again cases cannot be a supervening event or evidence per se to warrant a re-investigation on the same set of facts and circumstances do not lie. Res judicata is a doctrine of civil law and thus has no bearing on criminal proceedings. But even if petitioner's argument as were to be expanded to contemplate res judicata in prison gray, or the criminal law concept of double jeopardy, this court still finds it inapplicable to bar the reinvestigation conducted by the Office of the Ombudsman. An interlocutory order denying an application for bail, in this case being criminal in nature, does not give rise to res judicata. As in Trinidad, even if we are to expand the argument of the prosecution in this case to contemplate res judicata in prison gray, or double jeopardy, the same will still not apply. Double jeopardy requires that the accused has been convicted or acquitted, or that the case against him or her has been dismissed or terminated without his express consent. Here, while there was an initial ruling on Escobar's first bail petition, Escobar has not been convicted, acquitted, or has had his case dismissed or terminated. Even assuming that this case allows for res judicata as applied in civil cases, Escobar's second bail petition cannot be barred as there is no final judgment on the merits. Res judicata requires the concurrence of the following elements. 1. The judgment sought to bar the new action must be final. 2. The decision must have been rendered by a court having jurisdiction over the parties and the subject matter. 3. The disposition of the case must be a judgment on the merits, and 4. There must be between the first and second actions identity of parties, of subject matter, and of causes of action. In deciding on a matter before it, a court issues either a final judgment or an interlocutory order. A final judgment leaves nothing else to be done, because the period to appeal has expired or the highest tribunal has already ruled on the case. In contrast, an order is considered interlocutory if between the beginning and the termination of a case, the court decides on a point or matter that is not yet a final judgment on the entire controversy. An interlocutory order settles only some incidental, subsidiary or collateral matter arising in an action. In other words, something else still needs to be done in the primary case, the rendition of the final judgment. Res judicata applies only when there is a final judgment on the merits of a case. It cannot be availed if in an interlocutory order, even if this order is not appealed. For example, an order overruling a motion to dismiss does not give rise to res judicata, that will bar a subsequent action, because such order is merely interlocutory and is subject to amendments until the rendition of the final judgment. Stephen R. Pavlov, Petitioner, v. Cherry LMENDENILLA, Respondent. April 19, 2017. The mother of a victim of acts of violence against women and their children is expressly given personality by Section 9(b) of Republic Act No. 9262. Otherwise known as the Anti-Violence Against Women and Their Children Act of 2004, the anti-VAWC law, to file a civil action petitioning for the issuance of a protection order for her child. In filing such a petition, she avails of a remedy that is distinct from the criminal action under Section 5 of the same law. The mere filing of such a criminal complaint without the subsequent filing of an information in court does not occasion litis pendentia or res judicata that precludes the filing of a petition for the issuance of a protection order. Actions in rem are quasi in rem where what is imperative is jurisdiction over the res. In these actions, service of summons upon the defendant primarily serves the interest of due process, and not so much the purpose of acquiring jurisdiction over his or her person. Representative Act No. 9262, Sec. 9 provides. Section 9. Who may file petition for protection orders? A petition for protection order may be filed by any of the following. B. Parents or guardians of the offended party. Representative Act No. 9262, Sec. 15 provides. Section 15. Temporary protection orders. Temporary protection orders (TPOs) refers to the protection order issued by the court on the date of filing of the application after ex parte determination that such order should be issued. A court may grant in a TPO any, some or all of the reliefs mentioned in this act and shall be effective for 30 days. The court shall schedule a hearing on the issuance of a PPO prior to or on the date of the expiration of the TPO. The court shall order the immediate personal service of the TPO on the respondent by the court sheriff, who may obtain the assistance of law enforcement agents for the service. The TPO shall include notice of the date of the hearing on the merits of the issuance of a PPO. Representative Act No. 9262, Sec. 14 provides. Section 14. Barangay Protection Orders BPOs, who may issue and how. Barangay Protection Orders BPOs refer to the protection order issued by the punong barangay ordering the perpetrator to desist from committing acts under Section 5 and B of this Act. A punong barangay who receives applications for a BPO shall issue the protection order to the applicant on the date of filing after ex parte determination of the basis of the application. If the punong barangay is unavailable to act on the application for a BPO, the application shall be acted upon by any available barangay kagawad. If the BPO is issued by a barangay kagawad, the order must be accompanied by an attestation by the barangay kagawad that the punong barangay was unavailable at the time for the issuance of the BPO. BPOs shall be effective for 15 days. Immediately after the issuance of an ex parte BPO, the punong barangay or barangay kagawad shall personally serve a copy of the same on the respondent, or direct any barangay official to effect its personal service. The parties may be accompanied by a non-lawyer advocate in any proceeding before the punong barangay. The second sentence of Section 10 of Representative Act No. 9262 states, an application for a TPO or PPO may be filed in the Regional Trial Court, Metropolitan Trial Court, Municipal Trial Court, Municipal Circuit Trial Court with territorial jurisdiction over the place of residence of the petitioner. Provided, however, that if a family court exists in the place of residence of the petitioner, the application shall be filed with that court. Representative Act No. 9262, Sec. 15 provides. Section 15. Temporary Protection Orders. Temporary Protection Orders TPOs refers to the protection order issued by the court on the date of filing of the application after ex parte determination that such order should be issued. A court may grant in a TPO any, some or all of the reliefs mentioned in this Act and shall be effective for 30 days. The court shall schedule a hearing on the issuance of a PPO prior to or on the date of the expiration of the TPO. The court shall order the immediate personal service of the TPO on the respondent by the court sheriff, who may obtain the assistance of law enforcement agents for the service. The TPO shall include notice of the date of the hearing on the merits of the issuance of a PPO. Representative Act No. 9262, Sec. 5 provides. Section 5. Acts of violence against women and their children. The crime of violence against women and their children is committed through any of the following acts. A. Causing physical harm to the woman or her child. B. Threatening to cause the woman or her child physical harm. C. Attempting to cause the woman or her child physical harm. D. Placing the woman or her child in fear of imminent physical harm. E. Attempting to compel or compelling the woman or her child to engage in conduct which the woman or her child has the right to desist from, or to desist from conduct which the woman or her child has the right to engage in, or attempting to restrict or restricting the woman's or her child's freedom of movement or conduct by force or threat of force, physical or other harm or threat of physical or other harm, or intimidation directed against the woman or her child. This shall include, but not limited to, the following acts committed with the purpose or effect of controlling or restricting the woman's or her child's movement or conduct. 1. Threatening to deprive or actually depriving the woman or her child of custody or access to her his family. 2. Depriving or threatening to deprive the woman or her children of financial support legally due her or her family, or deliberately providing the woman's children insufficient financial support. 3. Depriving or threatening to deprive the woman or her child of a legal right. 4. Preventing the woman in engaging in any legitimate profession, occupation, business or activity, or controlling the victim's own money or properties, or solely controlling the conjugal or common money or properties. F. Inflicting or threatening to inflict physical harm on oneself for the purpose of controlling her actions or decisions. G. Causing or attempting to cause the woman or her child to engage in any sexual activity which does not constitute rape by force or threat of force, physical harm, or through intimidation directed against the woman or her child or his immediate family. H. Engaging in purposeful, knowing, or reckless conduct, personally or through another, that alarms or causes substantial emotional or psychological distress to the woman or her child. This shall include, but not be limited to, the following acts. 1. Stalking or following the woman or her child in public or private places. 2. Peering in the window or lingering outside the residence of the woman or her child. 3. Entering or remaining in the dwelling or on the property of the woman or her child against her his will. 4. Destroying the property and personal belongings or inflicting harm to animals or pets of the woman or her child, and 5. Engaging in any form of harassment or violence. I. Causing mental or emotional anguish, public ridicule or humiliation to the woman or her child, including, but not limited to, repeated verbal and emotional abuse. And denial of financial support or custody of minor children or denial of access to the woman's children. Defined in Section 3 of Representative Act No. 9262 as follows. Section 3. Definition of terms. As used in this Act, violence against women and their children refers to any act or a series of acts committed by any person against a woman who is his wife, former wife, or against a woman with whom the person has or had a sexual or dating relationship, or with whom he has a common child, or against her child whether legitimate or illegitimate, within or without the family abode, which result in or is likely to result in physical, sexual, psychological harm or suffering, or economic abuse including threats of such acts, battery, assault, coercion, harassment or arbitrary deprivation of liberty. It includes, but is not limited to, the following acts. A. Physical violence refers to acts that include bodily or physical harm. B. Sexual violence refers to an act which is sexual in nature, committed against a woman or her child. It includes, but is not limited to, rape, sexual harassment, acts of lasciviousness, treating a woman or her child as a sex object, making demeaning and sexually suggestive remarks, physically attacking the sexual parts of the victim's body, forcing him to watch obscene publications and indecent shows, or forcing the woman or her child to do indecent acts and or make films thereof, forcing the wife and mistress lover to live in the conjugal home or sleep together in the same room with the abuser. B. Acts causing or attempting to cause the victim to engage in any sexual activity by force, threat of force, physical or other harm, or threat of physical or other harm or coercion. C. Prostituting the woman or her child. C. Psychological violence refers to acts or omissions causing or likely to cause mental or emotional suffering of the victim, such as but not limited to intimidation, harassment, stalking, damage to property, public ridicule or humiliation, repeated verbal abuse and marital infidelity. It includes causing or allowing the victim to witness the physical, sexual or psychological abuse of a member of the family to which the victim belongs, or to witness pornography in any form, or to witness abusive injury to pets, or to unlawful or unwanted deprivation of the right to custody and or visitation of common children. D. Economic abuse refers to acts that make or attempt to make a woman financially dependent, which includes, but is not limited to, the following. 1. Withdrawal of financial support or preventing the victim from engaging in any legitimate profession, occupation, business or activity, except in cases wherein the other spouse partner objects on valid, serious and moral grounds as defined in Article 73 of the Family Code. 2. Deprivation or threat of deprivation of financial resources and the right to the use and enjoyment of the conjugal, community or property owned in common. 3. Destroying household property. 4. Controlling the victim's own money or properties, or solely controlling the conjugal money or properties. Section 8. Protection orders. A protection order is an order issued under this Act for the purpose of preventing further acts of violence against a woman or her child specified in Section 5 of this Act and granting other necessary relief. The relief granted under a protection order should serve the purpose of safeguarding the victim from further harm, minimizing any disruption in the victim's daily life, and facilitating the opportunity and ability of the victim to independently regain control over her life. The provisions of the protection order shall be enforced by law enforcement agencies. The protection orders that may be issued under this Act are the Barangay Protection Order (BPO), Temporary Protection Order (TPO), and Permanent Protection Order (PPO). The protection orders that may be issued under this Act shall include any, some or all of the following reliefs. A. Prohibition of the respondent from threatening to commit or committing, personally or through another, any of the acts mentioned in Section 5 of this Act. B. Prohibition of the respondent from harassing, annoying, telephoning, contacting or otherwise communicating with the petitioner, directly or indirectly. C. Removal and exclusion of the respondent from the residence of the petitioner, regardless of ownership of the residence, either temporarily for the purpose of protecting the petitioner, or permanently where no property rights are violated, and if respondent must remove personal effects from the residence, the court shall direct the law enforcement agent to accompany the respondent to the residence, remain there until respondent has gathered his things and escort respondent from the residence. D. Directing the respondent to stay away from petitioner and any designated family or household member at a distance specified by the court, and to stay away from the residence, school, place of employment, or any specified place frequented by the petitioner and any designated family or household member. E. Directing lawful possession and use by petitioner of an automobile and other essential personal effects, regardless of ownership, and directing the appropriate law enforcement officer to accompany the petitioner to the residence of the parties to ensure that the petitioner is safely restored to the possession of the automobile and other essential personal effects, or to supervise the petitioner's or respondent's removal of personal belongings. F. Granting a temporary or permanent custody of a child, children to the petitioner. G. Directing the respondent to provide support to the woman and or her child if entitled to legal support, notwithstanding other laws to the contrary. The court shall order an appropriate percentage of the income or salary of the respondent to be withheld regularly by the respondent's employer and for the same to be automatically remitted directly to the woman. Failure to remit and or withhold or any delay in the remittance of support to the woman and or her child without justifiable cause shall render the respondent or his employer liable for indirect contempt of court. H. Prohibition of the respondent from any use or possession of any firearm or deadly weapon, and order him to surrender the same to the court for appropriate disposition by the court, including revocation of license and disqualification to apply for any license to use or possess a firearm. If the offender is a law enforcement agent, the court shall order the offender to surrender his firearm and shall direct the appropriate authority to investigate on the offender and take appropriate action on the matter. I. Restitution for actual damages caused by the violence inflicted, including, but not limited to, property damage, medical expenses, childcare expenses and loss of income. J. Directing the DSWD or any appropriate agency to provide petitioner temporary shelter and other social services that the petitioner may need, and K. Provision of such other forms of relief as the court deems necessary to protect and provide for the safety of the petitioner and any designated family or household member, provided petitioner and any designated family or household member consents to such relief. Any of the reliefs provided under this section shall be granted even in the absence of a decree of legal separation or annulment or declaration of absolute nullity of marriage. The issuance of a BPO or the pendency of an application for BPO shall not preclude a petitioner from applying for, or the court from granting a TPO or PPO. Substituted service may be resorted to. If, for justifiable causes, the defendant cannot be personally served within a reasonable time. This case pertains to alleged acts of violence against a woman. Petitioner was alleged to have physically and psychologically assaulted his wife, Maria Sheila, on multiple occasions. Maria Sheila was noted to have had to be confined in a medical facility on account of petitioner's assaults. Maria Sheila's mother found herself having to intervene to protect her daughter. The totality of these entails an urgency which, by statute, justifies the issuance of a temporary protection order even as the respondent to Mendelila's petition was yet to be heard. This is an urgency which the regional trial court actually found to be attendant, as it did, in fact, issue a temporary protection order. Time was of the essence. The exigencies of this case reveal a backdrop of justifiable causes and how, by the convenience of petitioner Stephen Pablo's temporary absence, immediate personal service was rendered impossible. These exigencies justified substituted service of summons upon petitioner during his temporary absence through Monet Tolentino, a person of suitable age and discretion, who also resided at petitioner's own residence. Jurisdiction over petitioner's person was then validly acquired, and the dismissal of respondent Cheriel Mendanila's petition on this score was correctly held by Judge Natividad Gorandisan to be unwarranted. Jurisprudence has long settled that, with respect to residents temporarily out of the Philippines, the availability of extraterritorial services does not preclude substituted service. Resort to substituted service has long been held to be fair, reasonable and just. This court has noted that a contrary, restrictive view is that which defeats the ends of justice. It has been emphasized that residents who temporarily leave their residence are responsible for ensuring that their affairs are in order, and that, upon their return, they shall attend to exigencies that may have arisen. In Montalban v. Maximo, 76. This brings us to the question of procedural due process. Substituted service upon a temporarily absent resident, it has been held, is wholly adequate to meet the requirements of due process. The constitutional requirement of due process exacts that the service be such as may be reasonably expected to give the notice desired. Once the service provided by the rules reasonably accomplishes that end, the requirement of justice is answered, the traditional notions of fair play are satisfied, due process is served. People of the Philippines, Petitioner v. George Gacasan, Respondent. The abuse of moral influence is the intimidation required in rape committed by the common-law father of a minor. In People v. Robles, accused Robles raped his common-law wife's daughter. This court affirmed his conviction and likened Robles' moral ascendancy over the victim to that of a biological father, thus, moral ascendancy and influence by the accused stepfather of the 12-year-not-old complainant, and threat of bodily harm rendered complainant subservient to appellant's lustful desires. Actual force or intimidation need not even be employed for rape to be committed where the overpowering influence of a father over his daughter suffices. 101 Emphasis provided, citation omitted. Gacasan had moral ascendancy over AAA. In this case, therefore, the issue regarding the need to prove actual force or intimidation becomes superfluous since it was already established that Gacasan was the common-law partner of AAA's deceased mother. Furthermore, apart from Gacasan's moral ascendancy over AAA, it is apparent that he also had physical advantage over her. Given all these reasons, AAA was left without any other choice but to succumb to Gacasan's sordid acts. People of the Philippines, Plaintiff Appellee v. Z's, accused appellant. June 19, 2019. Note that this is a 2019 case. Recantations are viewed unfavorably, especially in rape cases. Circumstances in which the recantation was made are thoroughly examined before the evidence of retraction can be given any weight. In People v. Dalen, the gravamen of the offense of statutory rape, as provided for in Article 266(8) paragraph 1d of the Revised Penal Code, as amended, is the carnal knowledge of a woman below 12 years old. To convict an accused of the crime of statutory rape, the prosecution must prove first, the age of the complainant, second, the identity of the accused, and last but not the least, the carnal knowledge between the accused and the complainant. As explained in People v. Osing. Air touching, no matter how slight of the labia or lips of the female organ by the male genital, even without rupture or laceration of the hymen, is sufficient to consummate rape. The absence of fresh hymenal laceration does not disprove sexual abuse, especially when the victim is a young girl. This court has consistently held that an intact hymen does not negate the commission of rape. The element of rape does not even include hymenal laceration. The absence of external signs or physical injuries on the complainant's body does not necessarily negate the commission of rape, hymenal laceration not being, to repeat, an element of the crime of rape. A healed or fresh laceration would of course be a compelling proof of defloration. What is more, the foremost consideration in the prosecution of rape is the victim's testimony and not the findings of the medico-legal officer. In fact, a medical examination of the victim is not indispensable in a prosecution for rape. The victim's testimony alone, if credible, is sufficient to convict. Quirino T. de la Cruz v. National Police Commission, January 7, 2019. Note that this is a 2019 case. The relaxation of procedural rules is warranted only if compelling and justifiable reasons exist. In Asia, United Bank v. Goodland Company. The relaxation or suspension of procedural rules or the exemption of a case from their operation is warranted only by compelling reasons or when the purpose of justice requires it. As early as 1998 in Hun. Fortick v. Hun. Coronate expounded on these guiding principles. Procedural rules, we must stress, should be treated with utmost respect and due regard since they are designed to facilitate the adjudication of cases to remedy the worsening problem of delay in the resolution of rival claims and in the administration of justice. The requirement is in pursuance to the PRICILLA inscribed in the Constitution, which guarantees that all persons shall have a right to the speedy disposition of their cases before all judicial, quasi-judicial and administrative bodies. The adjudicatory bodies and the parties to a case are thus enjoined to abide strictly by the rules. While it is true that a litigation is not a game of technicalities, it is equally true that every case must be prosecuted in accordance with the prescribed procedure to ensure an orderly and speedy administration of justice. There have been some instances wherein this court allowed a relaxation in the application of the rules. But this flexibility was never intended to forge a bastion for litigants to violate the rules with impunity. A liberal interpretation and application of the rules of procedure can be resorted to only in proper cases and under justifiable causes and circumstances. This is not a case that calls for relaxation of the rules. This court will not tolerate abuse of police authority over civilians. Where a police officer has been shown to have committed atrocities against a civilian, such as in this case, and is punished for his actions, he will find no relief in this court. Maria C. Osorio Petitioner v. People of the Philippines, July 2, 2018. Persons who receive money for investment in a particular company but divert the same to another without the investor's consent may be held criminally liable for other deceits under Article 318 of the Revised Penal Code. Article 318 of the Revised Penal Code is broad in scope, intended to cover all other kinds of deceit not falling under Articles 315, 316, and 317 of the Revised Penal Code. In the information filed against her, the petitioner with crime of estafa under Article 315, paragraph 2d of the Revised Penal Code, which reads, D. By post-dating a check, or issuing a check in payment of an obligation when the offender had no funds in the bank, or his funds deposited therein were not sufficient to cover the amount of the check. The failure of the drawer of the check to deposit the amount necessary to cover his check within 3 days from receipt of notice from the bank and or the payee or holder that said check has been dishonored for lack or insufficiency of funds shall be prima facie evidence of deceit constituting false pretense or fraudulent act. As amended by Representative Act No. 4885, approved June 17, 1967. Rule 120. Judgment. Section 4. Judgment in case of variance between allegation and proof. When there is variance between the offense charged in the complaint or information and that proof, and the offense is charged is included in or necessarily includes the offense proved, the accused shall be convicted if the offense proved which is included in the offense charged, or of the offense charged which is included in the offense proved. Simply put, an accused may be convicted of an offense proved provided it is included in the charge, or of an offense charged which is included in that which is proved. In the case at bar, the petitioner was convicted of the crime falling under other deceits, which is necessarily included in the crime of estafa under Article 315. Paragraph 2d, considering that the elements of deceit and damage also constitute the former. Hence, the petitioner's right to be properly informed of the accusation against her was never violated. In the present case, the crime of other deceits under Article 318 of the Revised Penal Code is necessarily included in the crime of estafa by means of deceit under Article 315(2) of the Revised Penal Code. Therefore, the petitioner may be convicted of other deceits under Article 318 of the Revised Penal Code. RPC, Article 318. Other deceits. The penalty of arresto mayor and a fine of not less than the amount of the damage caused and not more than twice such amount shall be imposed upon any person who shall defraud or damage another by any other deceit not mentioned in the preceding articles of this chapter. Any person who, for profit or gain, shall interpret dreams, make forecasts, tell fortunes, or take advantage of the credulity of the public in any other similar manner, shall suffer the penalty of arresto menor or a fine not exceeding 200 pesos. Representative Act No. 10,951, Sec. 86 provides. Section 86, Article 318 of the same Act is hereby amended to read as follows. Article 318, Other Deceits. The penalty of arresto mayor and a fine of not less than the amount of the damage caused and not more than twice such amount shall be imposed upon any person who shall defraud or damage another by any other deceit not mentioned in the preceding articles of this chapter. Any person who, for profit or gain, shall interpret dreams, make forecasts, tell fortunes, or take advantage of the credulity of the public in any other similar manner, shall suffer the penalty of arresto mayor or a fine not exceeding 40,000 pesos p. 40,000. The indeterminate sentence law is inapplicable because the maximum term of imprisonment does not exceed 1 year. Jesus A. PARENTEYVOCALAN, Petitioner v. People of the Philippines, Respondent. September 27, 2017. Where the amount of narcotics seized is minuscule, a stricter adherence to the requirements of Section 21 of Republic Act No. 9165 is required to preserve the evidentiary value of the seized drugs. It appears from the record that the seized drugs were not marked by the apprehending team but by an investigating officer at the police station, an act which is not in accordance with Republic Act No. 9165. Further, no justifiable reason for this was presented by the prosecution. This court stresses that where minuscule amounts of drugs are involved, trial courts should require more exacting compliance with the requirements under Section 21 of Republic Act No. 9165. Consequently, the trial court and the Court of Appeals should have considered the failure of the apprehending team to mark the seized drugs immediately after seizure and confiscation. They should also have considered that it was the investigating officer at the police station who marked the same and not the arresting officers. The failure of the prosecution to address this issue and to provide a justifiable reason for this are enough to cast a shadow of doubt on the integrity of the operation. BANGKOSENTRAL in Filipinos, Petitioner, v. Commission on Audit, Respondent. September 19, 2017. Note that this is an en banc case. Due process in administrative proceedings does not require the submission of pleadings or a trial type of hearing. However, due process requires that a party is duly notified of the allegations against him or her and is given a chance to present his or her defense. Due process in administrative proceedings does not require the submission of pleadings or a trial type of hearing. Due process is satisfied if the party is duly notified of the allegations against him or her and is given a chance to present his or her defense. Furthermore, due process requires that the proffered defense should have been considered by the tribunal in arriving at its decision. 86. This finds basis in Angdabay v. Court of Industrial Relations, 87, which ruled that administrative due process only requires the following. A. The party should be allowed to present his or her own case and submit supporting evidence. B. The deciding tribunal must consider the party's evidence. C. There is evidence to support the tribunal's decision. D. The evidence supporting the tribunal's decision must be substantial or such relevant evidence as a reasonable mind might accept as adequate to support a conclusion. E. The tribunal's decision was based on the evidence presented or the records of the case disclosed to the parties. F. The tribunal's decision must be based on the judge's independent consideration of the facts and law governing the case, and G. The tribunal's decision must be rendered such that the issues of the case and the reasons for the decisions are known to the parties. 88.